subcommittee will come to order. Within the last few months, the American people and the rest of the world have become privy to an astonishing number of revelations concerning the secret operations of our armed forces and national intelligence agencies. We have learned that a Pakistani doctor cooperated with U.S. forces in conducting DNA tests to help locate Osama bin Laden. We have learned that the President of the United States personally decides the human targets of drone strikes in other countries by looking at mugshots and brief biographies of targets, and that, we have been told, resembled a high school yearbook layout. We have learned that the United States, in cooperation with its ally Israel, sabotaged the Iranian nuclear campaign with the Stuxnet virus. We have learned that Obama expanded the assault even after the virus accidentally made its way into the Internet in 2010. We have learned that the United States sabotaged Iranian computers with the flame virus. We have learned that the CIA takedown of an al-Qaeda plot to blow up the U.S.-bound airliner involved an international sting operation with a double agent tricking terrorists into handing over a prized possession, a new bomb purportedly designed to slip through airport security. We have also learned that the double agent belonged to another ally, Saudi Arabia. We didn't learn of these secret programs and details through spies or other countries' diplomats, or even from the WikiLeaks scandal. We learned of these secrets from the pages of the New York Times and other newspapers. The editors of the New York Times and other newspapers have publicly claimed many times that they see themselves as having a duty to inform. During the Bush administration, the New York Times and other newspapers savaged President Bush and the intelligence community for its tactics in the war on terror. How times have changed. Here is a sample of the headlines that accompanied these latest national security leaks. Obama orders sped up waves of cyber attacks against Iran, the New York Times. Secret kill list proves a test of Obama's principles and will, New York Times. Stuxnet was the work of U.S. and Israeli experts, officials say, Washington Post. These are not the type of critical headlines that pursued Bush administration officials. Not only has the administration not complained about these articles, but officials make a planner, operator, and commander of SEAL Team 6, who killed Osama bin Laden, available to a Hollywood director and screenwriter working on a movie about this successful raid, according to Pentagon and CIA records obtained by Judicial Watch, who got the information through FOIA requests. The four leaders of the intelligence committees have condemned these leaks. Senator Feinstein said that she was deeply disturbed by these leaks and wants an investigation, and she's right. The Attorney General has deployed two U.S. attorneys who report to him to investigate the leaks and to determine whether anyone from the administration should be prosecuted. Today we'll have a look at the law and discuss the options available for investigating these disclosures to the press. These leaks threaten our national security, our relations with foreign governments, and continued candor from embassy officials and foreign sources. They already have had profound consequences. The doctor who cooperated with us was sentenced to 30 years in prison by Pakistani authorities. Intelligence sources have told us that the Saudi Arabian double agent was exposed because of news reports. As long as there have been governments, there have been information protected by those governments. This country needs its secrets kept, regardless if the news media wants to expose them, to condemn a president, or to praise him. This isn't simply about keeping the government's secret secret. This is about the safety of American personnel overseas at all levels, from the foot soldier to the commander-in-chief. It is now my pleasure to recognize for his opening statement the ranking member of this subcommittee, the distinguished gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. And today we'll examine issues related to leaks of sensitive government information, sometimes classified, sometimes not classified. This hearing is motivated in no small part by a recent spate of stories in the news that appear to have as their basis leaked information from within the federal government. These stories include details of cyber warfare in Iran, covert mission to thwart a suicide bomber bound for the United States and the administration's process of nominating individuals as targets for drone strikes in Yemen and in Pakistan. Although these stories may have given some members a renewed sense of urgency, it is important to put them in context. The 2 points to be made here. First, the Obama administration's work to investigate and prosecute suspected leaks is without peer. This administration has prosecuted more leaks than all previous presidential administrations combined. Attorney General Eric Holder has appointed 2 U.S. attorneys to lead the federal investigations into recent leaks. Director of National Intelligence James Clapper has issued new rules to deter further future incidents, among them rules authorizing the Inspector General of the Defense Community to conduct an independent administrative investigation, even if the Justice Department declines to bring criminal charges in a specific case. Second, the problem of leaks in the federal government is not new. There were spies at the founding of the Republic. We have grappled with this problem of federal law since the First World War. In the modern sense of leaking information to the press, we've had to work to balance our security interests of a free and robust press with the interests of a free and robust press for a better part of 50 years. These problems are not amenable to easy solutions, particularly in light of the fact that we do not always agree on the scope of the problem. We all want to protect national security so that we can keep our citizens safe, but we cannot disregard the right of American citizens in a system of self-governance, a system that requires the public to be well informed. When a government official leaks sensitive information to the press that reveals the government is engaged in unlawful activity, do we simply leave it up to the same government's discretion as to whether to prosecute the person for possibly serving the public's interest? What about leaks of information that do not implicate any national security interest at all? Overclassification is an enormous problem in the federal government, and current law does not distinguish between leaking classified information with the intent to harm the United States and blowing the whistle on unlawful activity that never should have been classified in the first place. Congress may soon consider legislation that attempts to address these shortcomings in existing law. As we move forward, we must be careful. Any decision to limit what the public officials and private citizens may say about sensitive government information must be balanced against the important issues of free speech, due process, and the requirement and the fact that some of this information may reveal improper or even criminal government actions. Just as the authors of the Espionage Act of 1917 did not anticipate our problems with leaks in the digital information age, there may be unforeseen consequences of any changes we make today. It is easy to overreact to news stories, particularly in an election year, but we must be careful before we limit what people say, particularly in respect to the operation of our government. Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you. The chair of the full committee, the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. And, Mr. Chairman, I associate myself with your opening statement. Mr. Chairman, recent leaks of highly classified information pose a serious threat to our national security and put the lives of Americans and our allies at risk. National security experts from both Republican and Democratic administrations have expressed outrage over the leaks and the effect they have on ongoing and future intelligence operations. What sets these leaks apart from other leaks we have seen is that the media reports that many of these have come from highly placed administration officials. If true, this means that administration officials are weakening our national security and endangering American lives. National security operational details exist to meet the covert needs of the intelligence community that protects the American people. As FBI Director Mueller recently testified, quote, "Leaks such as this threaten ongoing operations, puts at risk the lives of sources, makes it much more difficult to recruit sources, and damages our relationships with our foreign partners. And consequently, a leak like this is taken exceptionally seriously, and we will investigate thoroughly." Director Mueller went on to say, quote, "I don't want to use the word devastating, but this will have a huge impact on our ability to do our business. Your ability to recruit sources is severely hampered. So it is also so it also has some long-term effects, which is why it is so important to make certain that the persons who are responsible for the leak are brought to justice," end quote. News publications that publicize classified information claim to promote increased government transparency, but I wonder if their real motivation is self-promotion and increased circulation. They claim to be in pursuit of uncovering government wrongdoing, but dismiss any criticism that their actions may be wrong or damaging to our country. These leaks have also resurrected debate on First Amendment protections afforded to media publications. What are the boundaries of free speech? How do we balance this freedom with the government's need to protect certain information? I hope the Justice Department will bring the full force of the law against those who leak protected information. We can judge whether the administration is willing to conduct a serious and objective investigation by considering two factors. One, whether they will hold administration officials responsible, and two, whether the investigation is completed before the general election. Otherwise, the American people rightly can conclude that the administration is hiding the truth and has endangered American security and American lives. Mr. Chairman, finally, I want to say that the administration's track record is not encouraging. It was pointed out by the ranking member of the subcommittee a minute ago that the administration has, in fact, initiated a number of investigations of leaks. But very little, if anything, has come out of those investigations. I hope this time it will be different. Thank you, Mr. Chairman. I'll yield back.
The ranking member of the full committee, the distinguished gentleman from Michigan, Mr. Conyers.
Thank you, Chairman Sensenbrenner, and good morning to our witnesses. This is a difficult matter, national security leaks into law. My good friend from Texas, the chair of this full committee, wonders if self-promotion played a role and if there were prominent members of the administration involved in the leaks. Well, that's what we're here to try to determine. He hasn't mentioned any names, so I presume he's not sure who's doing it. We have our own investigative capacities, and so why don't we inquire ourselves? We also have the regular power of subpoena. If there's somebody he thinks we ought to talk to, we should talk to them. If there's somebody that isn't cooperating with us in this investigation, which is a legitimate subject for discussion, we should subpoena them.
If the gentleman will yield, I will take the gentleman up on his offer immediately, and I suspect the chairman of the subcommittee will as well. If you're going to support our efforts to subpoena individuals from the administration, I couldn't ask for more.
Well, that's why I'm suggesting it.
Well, if the gentleman will yield, if he will submit to the subcommittee chair a list of people that he wishes subpoenaed, and the full committee chair does the same, I think we can have a good bipartisan subpoena issuing session.
Yeah, the only problem is that at this point, neither of you have anybody that you want to subpoena, I presume, and neither do I.
Oh, I'll be happy to come up with some names.
Well, okay. Well, that's great. You know, we could have had this discussion before 10 a.m. on the 11th day of July, but right now, this hearing is going on without anybody knowing who they would like to talk with. And now we've all agreed to pull together 3 bipartisan lists. I'm very sure the former Attorney General from California, who is a member of the committee, he can easily come up with a list.
I'll give you some right now if you'd like to. How about all the people that were in the situation
Wait a
room that
minute,
was
I didn't
identified
yield.
by the New York
Just a
Times?
moment, sir. With you,
The time belongs to the gentleman from Michigan.
yeah, we can get you time, but I'm not here requesting names. I'm here pointing out that we don't apparently have any names. Now all of a sudden, we've got bipartisan panel. Everybody's willing to produce names. And by the way, I didn't say that I had any names myself. You're the ones running the committee and saying that this is an important subject, and I agree with you. But I just want to describe the nature of the setting as this starts out with. Now let me point out just a couple things. We must react to concerns about leaks in ways that do not undermine the openness and transparency of government. I think we can start off there as a beginning point. I think I would like to hear some discussion about the issue of overclassifications of documents in the federal government. I think that's worth our attention. And then a law passed in 1917 needs to be looked at again. What went on as espionage in the early part of the 20th century, I don't think has much relevance now, and I think there's a lot of work for the Committee on the Judiciary, and this subcommittee in particular.
The gentleman's time has
work on.
expired, and without objection, he's given 2 additional minutes.
Well, I thank you, but Chairman Sensenbrenner, and I won't use the 2 minutes. But I will just conclude by saying, when we look at the issue of leaks, let's look at them across a period of time that includes all the former as well as the current administration. And I thank you for your generosity, and I return the balance of the time. Thank you very much.
Thank you. Without objection, all members' opening statements will appear in the record at this point. Without objection, the chair is authorized to declare recesses during votes in the House floor. It is now my pleasure to introduce today's witnesses. Ken Weinstein is a partner in the law firm of Cadwalader, Wickersham, and Taft, where his practice focuses on corporate internal investigations. He is also an adjunct professor at Georgetown Law School. Mr. Weinstein served as an assistant U.S. attorney in both the Southern District of New York and in the District of Columbia. Later, he served as the U.S. attorney in D.C. and then was assistant attorney general for national security. He served as FBI Director Robert S. Mueller's chief of staff and then as President George W. Bush's Homeland Security advisor. He received his undergraduate degree from the University of Virginia and his law degree from the University of California at Berkeley. Mr. Nathan Sales is an assistant professor of law at the George Mason University School of Law. Before coming to George Mason, Sales was Deputy Assistant Secretary for Policy Development in the U.S. Department of Homeland Security. He previously served as counsel, then senior counsel in the Office of Legal Policy at the U.S. Department of Justice. He was the John M. Olin Fellow at Georgetown University Law Center in 2005 and 2006. From 2003 through 2005, he practiced at the Washington, D.C. law firm of Wiley, Ryan, and Fielding. Professor Sales clerked for the Honorable David B. Santel of the U.S. Court of Appeals for the D.C. Circuit. He received his undergraduate degree from Miami University and his J.D. from Duke. Colonel Ken Allard is a commentator on foreign policy and security issues. For more than a decade, he was a featured military analyst on NBC News, MSNBC, and CNBC. In 2006, he joined the faculty of the University of Texas San Antonio as an executive in residence and senior lecturer in management. His military career included overseas service as an intelligence officer, as well as tours of duty as an assistant professor at West Point Special Assistant to the Army Chief of Staff, and Dean of Students at the National War College. He received his undergraduate degree from Lycoming College, his MPA from Harvard, and his PhD in International Security from the Fletcher School of Law and Diplomacy at Tufts. Professor Stephen Vladek is a professor of law and the Associate Dean for Scholarship at American University, Washington College of Law. He is also a Supreme Court Fellow at the Constitution Project. He is a senior editor of the peer-reviewed Journal of National Security Law and Policy, a senior contributor to the Lawfare blog, a member of the Executive Committee of the Section on Federal Courts of the Association of American Law Schools. Previously, he was an associate professor of law at the University of Miami School of Law. Professor Vladek clerked for the Honorable Marcia S. Berzin on the U.S. Court of Appeals for the Ninth Circuit, and the Honorable Rosemary Barca on the U.S. Court of Appeals for the 11th Circuit. He received his Bachelor of Arts from Amherst and his J.D. from Yale Law School. The witnesses' full statements will be entered into the record in their entirety. I ask that each of you summarize in 5 minutes or less. And to help you stay with the time limit, there is a timing light on your table, and you all know what that means. So I now recognize Mr. Weinstein.
Chairman Sensenbrenner, Ranking Member Scott, Chairman Smith, Ranking Member Connors, and distinguished members of the subcommittee. It's an honor to appear before you today and to testify alongside my distinguished co-panelists. I spent much of my government career in the national security world, where I saw the vital role that sensitive information plays in our national security operations and how those operations can be put in jeopardy whenever that information is compromised. The problem of national security leaking has come to the fore recently because of several particularly damaging leaks over the last few months. While these recent leaks are alarming, the reality is that government leaking has been happening for as long as government has existed, and every American administration since the founding of the Republic has suffered its share of leaks. Leaks of national security information can compromise all aspects of our national security program. They can compromise specific national security operations, as happened in 2006 with the disclosure of the Treasury Department's secret program for tracking terrorist finances. They can compromise human sources, as apparently happened when it was recently reported that a Saudi source had helped to foil al-Qaeda's recent airplane bombing plot. And keep in mind that whenever a source's identity or existence is leaked, it not only negates the effectiveness of that particular source, it also undermines our ability to develop and cultivate sources in the future. Leaks can also compromise our methods, as apparently happened with the recent disclosure of our alleged use of malware to attack the Iranian nuclear weapons program. They can certainly endanger our government personnel, like the CIA chief of station, who was publicly outed and then killed by terrorists in Athens in the 1970s. And importantly, they can weaken our alliances, those operational relationships between us and foreign services that are so vital to our national security operations around the world. In short, leaks can be severely damaging to our efforts to protect our country. Now, there's a wide range of different types of leaks, but the most common scenario these days is the leak of sensitive information to the press by a government official, an official whose motivation may range from base self-interest to a laudable desire to blow the whistle on wrongdoing and change government operations for the better. I share Congress's concern about the need to enhance our defenses against such illicit disclosures. An important part of that effort is ensuring that in the appropriate cases, we investigate and we prosecute those who disclose our operational secrets. As you know, however, the Justice Department does not have a lengthy record of successful leak prosecutions. That thin track record is not for lack of trying, however. Rather, it's the result of myriad obstacles that stand in the way of building a prosecutable media leak case. Those obstacles are many, and they include the following. First, it's very difficult often to identify the leaker in the first place, given the large universe of people who are often privy to the sensitive information that gets disclosed. Second, our leak investigations operate under strict limitations in the Justice Department's internal regulations, limitations that are in place for all the right First Amendment reasons. And finally, even when investigators can get by those challenges and the leaks are identified, the agency whose information was compromised is often reluctant to proceed with the prosecution out of fear that trying the case in public will both highlight the compromised information and disclose further sensitive information that it wants to keep confidential. For all these reasons, leak investigations and leak cases are exceptionally challenging, and the question is whether any of these obstacles can or should be addressed by changes to the governing legislation. I agree with those who say that our current espionage statutes are cumbersome and antiquated, and I would support Congress's effort to reform them. Keep in mind, however, that this reform effort will be very complicated because it directly implicates the tension between national security and our cherished First Amendment values. Legislating in this area is challenging and inevitably raises a host of complex issues. For example, consideration of a law that would flatly prohibit and punish any disclosure of classified information will require examination of the problem of overclassification of government information. Also, any effort to revise the Espionage Act will lead to a debate whether the person who receives and publishes leaked information, i.e. the press, should be subject to the same criminal exposure as the government official who leaked it in the first place. These are certainly complex issues. Given the damage caused by the continued leaks and the inadequacy of our current leak legislation, however, it's important that Congress take these issues on and consider an appropriate legislative response. No matter where one stands on the political spectrum, we should all recognize that the unchecked leaking of classified and sensitive information can cause grave harm to our national security. Congress plays an important role in addressing that problem, and I applaud the committee for the initiative it's showing with today's hearing. I appreciate your including me in this important effort, and I stand ready to answer any questions you may have. Thank you, Mr. Chairman.
Thank you, Professor Sales.
Thank you. Chairman Sensenbrenner, Ranking Member Scott, Chairman Smith, Ranking Member Conyers, thank you all for, and other members of the subcommittee, thank you all for inviting me here to testify. It's a pleasure to appear before you again. I'd like to use my testimony to outline some of the legal tools the government has available to combat leaks. First, federal courts have held that it's a crime under the Espionage Act for officials to leak classified information to the press. Second, officials frequently sign secrecy agreements when they go to work for the government, and the Supreme Court has held that these secrecy contracts are enforceable. Now, these tools are useful, but they're not perfect. As we've already heard, the Espionage Act in particular is notoriously vague, and Congress might want to consider amending it. So let me go into more detail, starting with criminal prosecutions. The basic thrust of the Espionage Act is fairly straightforward. It's a crime for officials to, quote, reveal information relating to the national defense to any person not entitled to receive it. Now, this law, as the name implies, quite plainly applies to spies who give secrets to foreign governments. The courts have held that it also applies when officials give secrets to the press. The leading case is United States versus Morrison. Morrison was a naval intelligence officer, and he was convicted of violating the Espionage Act after he gave classified military photographs to a British magazine in 1984. The Fourth Circuit affirmed his conviction, squarely holding that the law applies to leakers, not just to spies. The reason leakers can be prosecuted, said the court, is because of the plain language of the statute. The Espionage Act doesn't refer narrowly to spies. It speaks in broad and comprehensive terms, nor does it contain any exception for leaks to the press. The court also emphasized the statute's purposes. Congress's goal in 1917 was to prevent secrets from falling into the wrong hands. That harm materializes regardless of whether our enemies get their secrets directly from spies or indirectly by reading about it in the newspaper. What about the Constitution? The Fourth Circuit rejected the notion that Morrison had a First Amendment right to leak. To hold otherwise, quote, would be to prostitute the salutary purposes of the First Amendment. Morrison is such an important precedent because it stands relatively alone. There simply aren't that many cases applying the Espionage Act to leakers. To this day, Morrison remains the only person ever convicted of leaking classified information to the press, though several others have pled guilty to similar charges. In fact, over the 100-year lifespan of the Espionage Act, the government has only brought charges against leakers 9 times. 6 of those prosecutions have come since President Obama took office in 2009. Next, I'd like to discuss a lesser-known but still important tool for combating leaks, contract law. Sometimes the government will get advance notice that an employee or former employee intends to leak classified information. That isn't just a potential crime, it's also a potential breach of contract. This is so because intelligence officials typically sign secrecy agreements as a condition of access to classified information. The government can go to court to have these contractual obligations enforced. Indeed, the Supreme Court and the Fourth Circuit have both upheld these sorts of secrecy agreements. The 2 cases, known as Snepp and Marchetti, each involved a former CIA official who wanted to publish a book about his time working at the agency. Again, the First Amendment is not an obstacle. According to the Supreme Court, the government's interest in preventing leaks is so strong it can restrict officials from revealing classified information even without an express contractual requirement to that effect. Finally, let me spend a couple seconds talking about how these laws might be improved. It's no secret that some of the key terms in the Espionage Act are ambiguous. Just what does information relating to the national defense mean anyway? And who specifically is a person not entitled to receive it? Judges and academics have been hoping that Congress would resolve these and other interpretive mysteries for more than a decade. There's another problem with the Act. The Espionage Act makes it a crime to leak information relating to the national defense as opposed to classified information, or properly classified information. As a result, the statute has the potential to produce both false positives and false negatives. In other words, the law might criminalize some leaks that aren't really harmful, and it might fail to criminalize other leaks that are harmful. Here's an example of the false negatives problem, which is probably more severe. Imagine what would happen if somebody leaked the U.S. negotiating strategy for ongoing talks over a free trade agreement. That information almost certainly doesn't relate to the national defense, but might nevertheless be properly classified. Because it doesn't fall within the four corners of the Espionage Act, it might not be unlawful, even though such a leak would cause exceptionally grave harm. Congress ought to consider, and indeed Congress has in the past considered, either tweaking the Espionage Act to resolve these ambiguities or perhaps to enact an entirely new statute. Mr. Chairman, thank you again for your time. Happy to answer any questions.
Yeah, thank you very much. Let me say that the yellow and red lights don't seem to be working, so I'll help the witnesses wrap up. And thank you, Professor. You wrapped up without any help. Colonel Allard. Could you please pull the mic a little bit closer to you and make sure it's turned on?
Appreciate your invitation and also the members of the committee. Mr. Chairman, on my way here, I had the occasion to stop at Midway Airport. And there at Midway Airport, they've dedicated a certain portion of the terminal to a memorial to Midway. Very appropriate. But while there was a great quote from Admiral Nimitz, who we in Texas are very, very proud of, because he was the hero of the Battle of Midway. What he said on that memorial, I think, is very, very important for us today. He looked back at the naval intelligence apparatus at Midway, and he said, the fate of the nation quite literally depended on a few dozen men who had devoted their lives and their whole careers in peace and war to radio intelligence. That intelligence gave us the edge at Midway. It literally meant the difference between life and death, victory and defeat. The topic which concerns us today is equally vital. The reason being, what has just happened is, in my lifetime, unprecedented. I mean, we all have seen leaks. I've been around government for the better part of 30 years. If you see government, you see leaks. Everyone understands this. And by the way, it's equally bipartisan. It occurs at every level, every administration. No one is exempt. And so if you try to amend the Espionage Act, you got to be very, very careful. But I very much associate myself with the idea of being extremely reluctant to mess with the law, because you know what? I think what you must do first is look back at the original consensus, going back all the way to Philadelphia, between freedom and responsibility, between particularly the obligation of those who are being defended to make sure those secrets are intact. What really concerns me today is the fact that we've seen, as I said, something I never thought I would ever see in my lifetime. When the Sanger articles began to appear, when his book appeared, I never thought I would see those revelations ever being discussed in the open press. The reason, when you commit industrial espionage against a sovereign power, ladies and gentlemen, that is by definition an act of war, pure and simple. And the key thing about intelligence, as Admiral Nimitz talked about, is it removes ambiguity. When ambiguity in intelligence is removed, armies march and navies sail. That's what just happened. Now, with Iran, the Islamic Republic of Iran, they've got links to terror that other people here are much more expert in than I am. But on this very Hill 2 days ago, you heard testimony from General Keith Alexander. General Alexander happens to have been my student at the National War College. What he said was, we are extremely vulnerable to any form of terrorism by virtue of cyber means. So when you do the same cyber means yourself, you can understand how it's sort of, people in glass houses should not throw stones. That's what just happened here. And when you look at that, it should bring the committee up very, very short, because you know what? You've got the responsibility of looking at the Espionage Act and thinking, can we do any better with this? I've got great respect for what this Congress can do in terms of investigation. I've been here as a congressional fellow myself. Mr. Smith, I do not normally admit that back in Texas, but it's true I was in these halls for 2 occasions. One was Goldwater-Nichols. The second was Federal Acquisition Streamlining Act of 1994. And both those acts were landmark legislation. They were both accompanied by a great degree of rigor, intellectual, every other way, analytical, to make sure that the laws that were being looked at were being analyzed correctly. With Goldwater-Nichols, defense organization was the oldest game in this town, save one other profession. It was looked at time and again, and finally people said, we need to adjust this law, here's why. With the Acquisition Streamlining Act, we looked at 800 laws and said, here is how defense procurement can be improved. Here's how and why, statute by statute. That was done. By the way, that statute that was passed in 1994 is still the leading statute for defense procurement today. So there's every means and every, I think, incentive for this committee to look very carefully at the Espionage Act. Mr. Conyers, you're absolutely correct, sir. It was passed World War I legislation, industrial age. We're now in an information age. What do you do when you've got open source intelligence? I defended the Constitution with my life for about over 25 years. For the last 15, I've been making a living from it. First with NBC News, and now doing some writing on my own. And I'll tell you, I've never seen anything remotely like this, where suddenly you have the access to information that you have. And so you have to sit here and make sense of all this and say, you know what, I believe in one of the statutes we looked at in the 94 legislation was whistleblowing. And guess what? That's extremely important to do now as well. The last thing I would say to you is you also have to be very careful about the institutions doing this. Because in the case of the New York Times, I'll tell you right now, personal experience, they abused their position. We see this time and again. What Mr. Sanger did was, I used to work against the KGB. Okay, what Mr. Sanger did is the equivalent of having a KGB operation being run against the White House. So when you investigate, what you should, I know how those things are done. I know about putting people in somewhat, let me put this fairly, make sure they're well aware of what their rights are, and make very sure of the fact that there's accountability there, first and foremost. That's the way this thing should be done, very carefully. But more than that, the thing I would just say to you is I also know how the press works, and I'll tell you one key thing. Make very sure that when you look at them, you're looking at this thing from the standpoint of the national interest, not the press interest. Thank you.
Professor Vladeck.
Thank you, Chairman Sensenbrenner, Ranking Member Scott, distinguished members of the subcommittee. Thank you for the invitation to testify today and in such distinguished company. I've had the honor of testifying previously alongside Professor Sales and Mr. Weinstein, but the fact that we and Colonel Allard continue to be called before you and other committees of the Congress to speak on the topic of national security leaks provides, in my view, fairly strong evidence of both the recurring nature of such unauthorized disclosures of classified information and the difficulties that generations of lawmakers, lawyers, and I dare say law professors have confronted in trying to address them. Thus, although I'm sure reasonable people will disagree about the politics of aggressively seeking to prosecute those allegedly responsible for the unauthorized disclosure of national security information, I hope to convince you of two related points that should transcend the politics of the moment. First, national security leaks are in many ways only a symptom of the much larger disease that has already been alluded to this morning of overclassification, a problem that Congress unquestionably has the power, if not always the inclination, to ameliorate. Second, even if this subcommittee believes that national security leaks by themselves are a problem worth a solution, and that this administration's fairly aggressive track record has not been sufficiently aggressive, the primary statute that the federal government has thus far used to prosecute alleged leakers, the Espionage Act, which we've already been discussing, is terribly ill-suited to the task. Instead, if Congress wants to pursue reform in this field, it must fundamentally revisit the federal classification scheme, and as part of that scheme, provide a far more narrowly tailored and carefully crafted sanction, specifically targeted at government employees who intentionally disclose properly classified information to the public without any intent to harm our national security. Until and unless reforms like these are undertaken, national security leaks will recur regardless of whether a Democrat or a Republican sits in the White House. What's more, given how many governmental abuses over the past decade have been publicly exposed only through these kinds of leaks, so long as the classification regime remains in its current form, this may not be an entirely undesirable result. I won't belabor the members with a long discourse on the pervasiveness of overclassification. Mr. Chairman, my written testimony has a little more on this, and certainly we can bring this up in the Q&A if it's relevant. I just want to add a couple of brief points about what has already been said with respect to the Espionage Act. So Mr. Wainstein, Professor Sales talked about the age of the Espionage Act, the ambiguity of the Espionage Act. I think it's also important to elaborate on a point that Mr. Wainstein made. The Espionage Act does not focus on the initial party who wrongfully discloses national defense information. Instead, it applies in its terms to anyone who knowingly disseminates, distributes, or even retains, and I think that's a very important point, retains national defense information to which they are not entitled without immediately returning that material to the relevant government officer authorized to possess it. In other words, the text of the Act draws no distinction between the leaker, the recipient of the leak, or the 100th person to redistribute, retransmit, or even retain the national defense information that by that point is already in the public domain. This is a big part of why the Act raises such profound First Amendment questions, not because, as Professor Sales suggested, of the First Amendment rights of the putative leaker, but because of the First Amendment rights of they who retransmit the leak and those of us who read about the leak on the pages of the New York Times, the Washington Post, and so on. Moreover, the potentially sweeping nature of the Espionage Act as currently written may inadvertently interfere with federal whistleblower laws. For example, the Federal Whistleblower Protection Act protects the disclosure of a violation of any law, rule, or regulation only if such disclosure is not specifically prohibited by law and if such information is not specifically required by executive order to be kept secret in the interest of national defense or the conduct of foreign affairs. Similar language appears in most other federal whistleblower statutes. Finally, the Espionage Act does not deal with the real elephant in the room, situations where individuals disclose classified information that should never have been classified in the first place, including information about unlawful government programs and activities. Most significantly, every court to consider the question has rejected the availability of a so-called improper classification defense, a claim by the defendant that he could not have violated the Espionage Act because the information he is disclosing should not have been classified. Testifying before the House Permanent Select Committee on Intelligence in 1979, Anthony Lapham, then the General Counsel of the CIA, described the uncertainty surrounding the Espionage Act as the worst of both worlds. As he explained, quote, "On the one hand, the laws stand idle and are not enforced, at least in part because their meaning is so obscure, and on the other hand, it is likely that the very obscurity of these laws serves to deter perfectly legitimate expression and debate by persons who must be as unsure of their liabilities as I am unsure of their obligations." Whatever one's views of national security leaks, Mr. Chairman, Lapham's central critique drives home why, regardless of who's in the White House, prosecuting national security leakers will always be a legally and politically fraught proposition. Thank you, and I look forward to your questions.
Okay, thank you very much. We will now have questions under the 5-minute rule, and first I will recognize the gentleman from California, Mr. Lundgren.
Thank you very much, Mr. Chairman. I appreciate that. Does anybody believe that the laws that we are talking about, particularly the Espionage Act, would not properly come into play with the alleged revelation of our participation, if true, in the Stuxnet virus or the Flame virus?
I'll give the law professor answer. I think it depends on how that information was actually disclosed. So,
Well, okay. You're going to the question, are you suggesting that it's a question of overclassification?
no, sir. I'm suggesting that there could be situations where information is disclosed because an official who has the authority to authorize such a disclosure provides that authority. And I don't know that we know whether or not that's true in this case.
Would it bother you to know that the detail that was described in the New York Times, if true, is a level of detail not presented to members of Congress, such as the chairman of the Cybersecurity Subcommittee on Homeland Security, that is, happens to be me.
I wouldn't have guessed.
So that, wouldn't that bother you that an administration that is supposed to be working with the proper role of the legislative branch to do oversight, utilizes classification in such a way that members are not aware of the particulars unless they read the New York Times. That is, if what's in the New York Times is true.
It would bother me. All I would point out is that it would hardly be the first time that members of Congress found out about those kinds of programs from the press as opposed to from the administration. I mean, it would bother me no matter who was in Congress and who was in the White House.
Because that also goes to the constitutional question of the powers of the legislative branch to do proper oversight to ensure that we are not having malefactors in the executive branch in areas of serious concern. Colonel, you said this is unprecedented.
Yes,
In your experience.
absolutely is.
And I know why I think it's unprecedented, but could you tell me why you believe it's unprecedented? In addition to the fact that, as you mentioned, the experience of Midway, I do recall there was an expression utilized during World War II that went, loose lips sink ships. They could certainly sink cybersecurity.
Absolutely can. For reasons that General Alexander pointed out on this very Hill 2 days ago. We are vulnerable to any form of cyber means. We're more dependent on these forms of computer-assisted everything than any other country on earth. So guess what? If a cyber virus comes into us, the same way that we did it to Iran, apparently, we are more vulnerable to this than the other guy. Why would you then do it? That's what bothers me the most, other than the fact that I read this in the New York Times. As I read his book, what really bothered me was the consistent access he had. Because you can't write, having written 5 books myself, you can't write a book unless you've been there and could actually talk about these things. He was actually there or had people in there who told him what actually occurred. When that degree of penetration is going on, as I said, that's like the KGB is actually in operation.
My observation is either the New York Times is lying or they had access to information of a particular detail that could only have come from someone who participated in the Situation Room. And as someone who's been involved in prosecutions in the past, you do look to motivation to try and figure out where your investigation would take you.
That's right.
Would it be unreasonable for us to subpoena individuals who would apparently be involved in the discussions that were revealed in these articles?
As I read not only Mr. Sanger's book, but also Bob Woodward's book 2 years ago, Obama's Wars, at least the first 2 chapters are classified top secret code word. As I looked at that, I thought, okay, if I were doing the investigation, I would say, cui bono, Cicero's great question. Who benefits? Whose position is enhanced by these leaks? That's where you begin the investigation.
I know who was not benefited by it. That is the Navy SEALs who were involved in the operations and their families. I know that those professionals who were working with us in the area of cybersecurity are not benefited by this. I know that the national security interests of the United States are not benefited by this. And so we ought to be looking at what is benefited by this.
The gentleman's time has expired. The gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Professor Sales, in 5 minutes, you can't detail things as you had in your statement. You went through the definition of the offense: willfully communicating, delivering, or transmitting any information related to the national defense to any person not entitled to receive it, if the official has reason to believe that the information could be used to injure the United States or advantage of any other country. I mean, a lot of words in there that are subject to interpretation. One is national defense. You talked about that a little bit. Is that limited to military?
It certainly includes military matters.
Includes
but not-
military. What about, you mentioned trade deals. Are trade deals not covered by, quote, national defense?
I don't think it clearly is covered in the way that intelligence information would be covered or military information would be covered.
Now, foreign intelligence in some of the legislation we've considered included trade deals.
I think a trade deal arguably could be in some circumstances, but it's not as clearly relevant as military information or intelligence information would be.
Are we talking about only classified information being covered, or can sensitive information that has not been classified be covered?
Under the current statute, it's possible that unclassified information that relates to the national defense could trigger criminal liability.
All classified information covered?
Not necessarily. There might be some forms of classified information that are not properly classified. There might be some forms of classified information that do not relate to national defense. And
Is improperly classified a defense to a criminal action?
as my friend and colleague, Professor Vladeck, has pointed out, most courts, in fact, I think all courts have rejected the notion that improper classification exonerates one under the Espionage Act.
Okay. Professor Vladeck, we had leaks to the press. I think one of the first cases was the Pentagon Papers. Is a reporter liable under this if he reports what he heard?
Congressman, we've talked about this before. I think that the text of the statute, I think, could be used to go after a reporter, not necessarily for the act of publishing this information, but even for the act of holding on to it when he's not entitled to. I think the government has always been very, very reluctant to pursue those cases because of the very serious First Amendment concerns they raised. But in the Pentagon Papers case you mentioned, Justice White specifically suggested in his concurrence that although the courts could not stop the New York Times from publishing the Pentagon Papers, the Nixon administration could potentially prosecute them after the fact.
So the state of the law now is what?
I think the best I can say is the law is unclear. I think there's only been one case in the history of the Espionage Act where the government has prosecuted a third party that is a recipient of the information as opposed to the leaker. That case fell apart. That was the APAC case in Virginia in 2005. I think there would be serious First Amendment concerns in such a case, but those concerns have not yet, produced an opinion saying that you cannot bring such a prosecution. So that's why I referenced that quote about the uncertainty about the scope of the statute.
Well, if you're talking about the press generally, we got some new problems. Who is a journalist and who isn't? Is a blogger a journalist?
Well, the Supreme Court, I think for that exact reason, has historically resisted giving special content to the press clause of the First Amendment because they don't want to draw the distinction between the New York Times and a blog. So I think that's only part of the murkiness here.
And then the WikiLink, is he a blogger or a journalist?
Well, I think if the government were to ever go after Julian Assange under the Espionage Act, I'm sure that he would try to raise a First Amendment claim along the lines that he is merely the press retransmitting this information.
So let me just kind of ask generally, what's the difference between somebody that leaks and a whistleblower?
Perspective?
Is that the intent to harm part of the statute?
I guess the problem is, Congressman, there are examples of individuals who have been prosecuted for leaking who saw themselves as whistleblowers. I think Thomas Drake is a very good example of that. And that's why I think it's a question of perspective. I think whistleblowing, if we understand whistleblowing to mean calling attention to waste or misconduct on the part of the government, I think sometimes that will include leaking information that is not properly in the public domain.
Colonel, do you want to comment on that?
There are two things. The test being, first of all, the subject matter. Is it relevant? Is it germane to the national defense? That test of legitimacy is key. The second being, what was your motivation? Any legal test also involves motivation, and was the motivation here a promiscuous release of government secrets, or was it intended to do something else? It's a very tough line to draw.
Thank you, Mr. Chairman.
Time of the gentleman has expired. The gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Weinstein, you said leaks have been around for time immemorial. It strikes me one way to have fewer leaks is to actually prosecute and put in prison the people who do the leaking. So I want to talk to you for a second. I couldn't find a federal statutory reporter privilege. Am I missing it?
You couldn't find a reporter privilege? No, you're right.
It doesn't exist in
doesn't
statute, so then we'd have to turn to the common law, and I'm not aware of any privileges that are unqualified, and certainly the reporter's privilege would be limited and would be qualified. So then we move to this area where, because it's the First Amendment, heavens knows we can't have any limitations on that. So I thought maybe you and I together, with the help from our friends who are law professors, could come up with some examples on where there are limitations of people's First Amendment rights I'll go first. Obscenity. What's another one, Professor?
Well, in Neer versus Minnesota, the Supreme Court.
You don't have to cite the cases.
Information about ships' sailing dates and troop.
How about deceptive advertising? How about students on high school campuses? They don't have the full panoply of First Amendment rights.
That's-
How about libel? How about government employees? So the notion that the First Amendment has no limitations whatsoever is balderdash, legally and otherwise. So that then leaves me with this conclusion. We are asking the U.S. Attorney, I think in the District of Columbia, to investigate leaks, and if he follows DOJ policy, he has to ask the Attorney General 4 months shy of an election for permission to subpoena a reporter in a case that may wind up being embarrassing for this administration. So why do we not have a special prosecutor in this case?
I think, Congressman, you're referring to the internal DOJ guidelines
Yes.
that require that the Attorney General personally sign off on a request to subpoena a reporter.
That's exactly right.
That's
DOJ
true.
policy.
It is DOJ policy. It's in place to protect the free press, to make sure that prosecutions don't chill the exercise of free press.
Right. It's certainly not the law. That's just DOJ policy.
It's not the law. If you look at the Espionage Act, there's nothing in the Espionage Act. As you pointed out, there's no privilege. Keep in mind, however, you can make leak investigations and leak prosecutions without actually subpoenaing the reporter.
You
and that has happened.
can, but you can also win murder cases without calling the eyewitnesses. You can win a murder case without calling the DNA expert. Why not send a subpoena to the reporter? Put them in front of a grand jury. You either answer the question or you're going to be held in contempt and go to jail, which is what I thought all reporters aspired to anyway.
Well,
I mean, all of us aspire to be committee chairman. I thought that that was the crown jewel in a reporter's resume, is to actually go to jail protecting a source. Give them what they want.
yeah, there was a reporter who got the crown jewel and spent whatever it was, 70 days in jail.
70 days.
In the
You can
Swain
sleep
case.
for 70 days.
But you make a good point, which is that the easiest way to make these cases is just go to the reporter. Either get the reporter's phone records, email records.
I mean, if
or
you were the
actually subpoena them,
prosecutor,
put them in the grand jury. That would be the
what would you
efficient way to
do
it.
other than that? If you were the prosecutor and your job was to get to the bottom of it as quickly as you could, you would send a subpoena to the reporter, right?
Right,
And put him in front of a grand jury.
right. And keep in mind, I'm going to defend the existence of that regulation, not necessarily defending the application of it and how stringently it should be applied.
I'm not saying that every line AUSA and every district in the country should be able to subpoena a reporter. I'm not saying that. I'm just saying that something as important and compelling, if you want to use a constitutional analysis, if you want to talk about the tiers of scrutiny, something as compelling as national security. And Ron Machen has to ask the Attorney General for permission to subpoena a reporter in what may be a very embarrassing fact pattern 4 months before a general election. We have to have confidence in the outcome, and you have to have confidence in the process. So why not do what lots of members of the House and Senate have asked and have a special prosecutor? Why not do it? I've never heard law professors this silent before.
I mean, I think I think it assumes facts, not in evidence, right? It assumes that the Attorney General, faced with a request from two U.S. attorneys, two highly regarded U.S. attorneys, specifically chosen for this task.
Well, has the
political
reporter appeared before a grand jury yet?
If they have, we wouldn't know because grand jury proceedings are sealed.
Oh, yeah. Well, then we get to
Time
leaks.
of the gentleman has expired. Gentleman from Michigan, Mr. Conyers.
Thank you very much. Chairman Sensenbrenner, I first of all want to compliment you on pulling together a stellar panel of witnesses who, from very varied experiences, have made this a very important and an interesting hearing. I wanted to begin with just two observations. One, I'd like any of you that would like to tell us about anything new and to your perspective of the subject of national security leaks in the law that have come to your attention as a result of the discussions that you've heard of your fellow panelists and the members of the committee. Does anyone have something they would like to add to the record? Colonel?
Mr. Conyers, when I talk about the fact that you've got to be very careful in revising the Espionage Act, I say that not only because I was a special agent myself, I've also been the subject of 4 congressional investigations, 4 federal investigations myself, based on this article, which came out in 2008. It took this committee, it took the 4 federal agencies 3 years, $2.3 million to exonerate these people that include myself. So guess what? When I talk about the fact of the protections of the law, I know what I'm talking about. I've not only been a special agent, I've also been a subject.
Yes.
So guess what? That's a chilling effect. You never forget that. Fortunately, I'm here to tell you that this should probably kill me first because I managed to succeed. And believe me when I tell you, when you defy federal agencies, if you're not right, they're coming after you. So I would simply say, when you try and enact legislation, be very careful, because you're going right back to Philadelphia. That
Thank
basic
you.
consensus that I think I
Thank you
talked
very
about in my
much.
statement.
Mr. Weinstein, what would you offer to this discussion, sir?
I guess you're asking if there's anything new today. The thing that struck me, and Steve Ladick and I were talking about this at the beginning, this is our 3rd hearing on this issue in the last year and a half. We testified in the Senate in 2010 about the Espionage Act. We testified here before you all in the aftermath of the WikiLeaks disclosures. And then today, all about what should we do about the Espionage Act. And I think, if anything, that reinforces my mind that there's a real imperative to take a look at the legislation and bring it into the modern age, because it needs reform.
Professor Sales?
Thank you, Congressman. One quick follow-up to what Mr. Weinstein just said. Congress actually did this in 2000. Congress, both houses passed legislation that would have created an entirely new statute along the lines we discussed earlier. Do away with the Espionage Act for dealing with leakers. The press is a totally separate issue and much more complicated issue. But as to the question of what do we do with government employees who leak, Congress actually solved that problem a decade ago. Unfortunately, the legislation was vetoed, so we're still waiting for more precise instructions on exactly what the scope of liability is for officials who leak.
Professor Vladeck, should we just rewrite the whole subject of security leaks, or should we just improve on the 1917 version?
You know, Congressman, I think I would actually go even further. I would say not only should there be a careful, calibrated amendment of the Espionage Act, but that I think Congress should see as part of that effort reforming the classification scheme. Because I think Congress has historically not exercised the power in that area that it, I think, clearly has. To not leave this all up to the executive branch's fiat. You know, the Atomic Energy Act of 1954 actually provides detailed classification rules for certain forms of information regarding our nuclear energy programs, but it's alone, right? All of the other classification is done by executive order. And so I think, you know, if the committee is serious about a workable system going forward, I think that system can't just include the back-end sanctions. It has to include the front-end rationalization of how we classify national security secrets.
I'd ask any of you that would like to submit this for the record, because time won't permit it today, but I'd like an evaluation of any of you about the following subjects: Watergate and the plumbers, the Pentagon Papers and Dan Ellsberg, and the whole concept of prior restraint. I'd appreciate anything that you could get on.
Where without objection, the material will be put in the record. We would like to publish the record sometime within the next 2 years, however, since this is somewhat of a broad request, but do your best. Gentlewoman from Florida, Ms.
Thank you.
Adams.
Thank you, Mr. Chairman. Mr. Weinstein, does leaking military field reports or diplomatic cables endanger innocent people and harm our national security?
Certainly can, and I think in the WikiLeaks case, we saw that there was danger presented to people, and particularly those folks who were over in the war zones who helped us out and who then got outed by those documents that were made public. Who knows what's happened to some of them, but I'm in fear for their lives.
And Colonel, if you could, how would you address to our allies, I'm sure they're concerned with the problems of our intelligence services, loss of confidence in our keeping the ability to keep secrets and such. How would you repair that damage, and how would you address it if you could?
I'm not sure. Ma'am, I was a young intelligence officer in Germany during the Church Committee hearings back in the 70s. I had sources look at me and say, you know what, I'm not going to do that for you because I don't want to see my name on the front page of the New York Times, Washington Post. I now know how they felt. And let me tell you something. When you have that reluctance of sources to believe in the confidence of the United States, that's a huge blow. It takes years to overcome this. And I don't think it will be overcome unless and until this Congress passes legislation which makes a sensible accommodation. But I absolutely agree with Professor Vladeck 100%. You got to address both the input as well as the output. We are overclassified, and so you try and protect everything, you protect nothing. And by the way, the American people are tired of paying the bill for these things. It costs money to classify, it takes money to protect it. We're not doing either thing very well.
Well, I have to tell you that here in your statements, act of war, KGB, unprecedented, consistent access to documents, information that should be classified. You would agree that you think this, if it was true, should have been classified?
Ma'am, there's no question about the fact that what is in Sanger's book, as well as on the front page of the New York Times, is a valid exercise in classification. If that's not classified, then nothing is.
So,
As I said, this affects American security of every single one of us here, every single one. If all of a sudden the utilities stop operating, you have him to thank for it.
so then you would agree that what you've read, if it in fact is true, should have been classified. Therefore, there should be a thorough and complete investigation.
There absolutely should. As I said in my statement, I was here when the Congress investigated. What really bothers me, I think, about this is it's become an agency for American secrets to wind up becoming reporters' profits. That's what's happened here.
And I agree that that should not be happening at the, I guess at the benefit of the reporters or whomever they're benefiting, but at the detriment of the American people. And as you said, we are vulnerable too, and this puts our American people at risk. And with that, I'm going to yield to my colleague, the astute, attorney, prosecutor, Trey Gowdy.
I was hoping to keep that a secret, but I thank the gentlelady from Florida
That's
for
because I'm a
outing
police
me
officer.
as a lawyer. Mr. Weinstein, I want you to assume that you and another highly decorated former prosecutor, the former Attorney General from the great state of California, Mr. Lundgren, were appointed special counsel. You would subpoena the reporter, and you would subpoena everyone in the Situation Room, right, before a grand jury.
Well, Congressman, I have to go back to what Steve Vladeck said. It sort of depends on the circumstances in terms of, who would be in the zone of interest. It depends on where the source came from, where the leak came from. In terms of the reporter, I think that special counsel, at least I believe, don't quote me on this, but I believe they might not be encumbered by the same regulations. Right. So they might be able to go ahead and subpoena the reporter. However, they're going to be sensitive to the First Amendment concerns as well, and I wouldn't be surprised if special counsel does try to exhaust other avenues of investigation before immediately.
Well, and that leads to my final question, which is this. Why would the reporter be entitled to any more protection than those in the Situation Room or someone who worked on the White House staff who may have overheard it? Why are we affording, because it's not statutory and the common law is weak as water, why are you giving more protection to a reporter than you are anyone in the Situation Room if they were subpoenaed?
It's purely, and this has been on the part of both administrations over time, it's a concern with not chilling the free press. It's a recognition that reporters serve a very important function in our society, and if we start subpoenaing them in with regularity, they're going to be less energetic in trying to root out information from the government. And reporters, as you know, reporters serve a very important function of disclosing wrongdoing within the government. Not necessarily secrets, but wrongdoing. So it's a balancing act, and that's the reason why those regulations are there. That's the reason for the reluctance to just willy-nilly subpoena reporters in on a regular basis. That being said, I'm firmly support, when the time is right and the circumstances justify it, to bring the reporter in, especially in a case where there's serious damage to the national security.
Gentleman's time has expired. Gentlewoman from California, Ms. Chu.
Thank you, Mr. Chair. I'd like to ask a question to Professor Sales and see what Professor Vladeck might think about this afterwards. And it's a follow-up on the issue of the press. It's been suggested by some critics that one way to ebb the flow of classified information is to discourage the press from publishing such information by filing criminal charges or seeking injunctions from courts. However, both of these approaches raise constitutional concerns as it pertains to restricting free speech. How do we balance the need to keep certain information confidential with the importance of upholding free speech and freedom of the press?
Thank you, Congresswoman. If I had an answer to that question, I'd probably be a dean instead of a professor. That is the million-dollar question. There are compelling values on both sides of the ledger. On the one hand, the First Amendment is a guarantee not only of individual rights to speak and receive information, but also a profound civic value in favor of open government, debate, and democracy. And you can't have that without transparency and openness. On the other hand, highly classified and properly classified national security information needs to be kept secret. If it leaks, we can't wiretap Osama bin Laden. If it leaks, sources get caught in the Kremlin and killed.
Yep.
How to balance those two different sets of considerations, equally vital values pulling in different directions, it's impossible, I think, to say in the abstract. I think that question can only be resolved in the context of a specific case. So in the New York Times case, the famous Pentagon Papers case, what kind of information is at stake there? Well, as it turns out, the information, though classified, wasn't really all that embarrassing anyway. Well, it was embarrassing, but it wasn't operational details. Here's the name of our source in Hanoi, right? It was a history of how the U.S. involvement in Southeast Asia. When balanced against the compelling interest in free speech, it's easy to see why information of that minimal sensitivity, not no sensitivity, but minimal sensitivity, why the balance tilts in favor of the press. But on the other hand, information about the name of the Pakistani doctor who assisted us in tracking down Osama bin Laden and who now is in jail for 3 decades, that has a much more profound harm to the national security. And so the First Amendment equities in that case might look very different.
Professor Vladeck?
I would just add, I actually think this ties in nicely with Congressman Gowdy's colloquy with Mr. Weinstein, because I think Mr. Weinstein suggested that the Attorney General guideline is there to protect the press. I actually think it's also there to protect the government, because I think the more the government goes after the press, the more the government is seen as not exercising care and diligence in pursuing the press in cases like this, the more the courts, I think, will be inclined to step in and protect the press, right? So I think the government builds its credibility for cases along the lines that Professor Sales describes, where it might actually really have a strong case by not running to the courthouse for a subpoena every single time that it looks like there's a national security leak. I think that the reality is this balance is impossible to strike in the abstract. The closest the Supreme Court has come is the accommodation it made in the Pentagon Papers case, which is prior restraints are the highest bar and are the most disfavored, and after-the-fact prosecutions are a separate issue that we'll worry about when we get there. And I think it says a lot about the national security leaks we have weathered over time, that there has never been a prosecution of a member of the press for violating the Espionage Act. That we've never had one, I think, is actually as strong a testament to striking that balance carefully as anything I could say.
Professor Vladeck, I also wanted to ask about the question of whether we should distinguish between motivations for leaks. There are lots of different reasons why a leak could occur. Some are motivated by government whistleblowing and seeking to raise awareness about an issue or policy. Other leaks indeed might be motivated by maliciousness. Still others might be just doing it because of flattery by a courting reporter. How much consideration should be given to understanding the motivation behind a leak?
It's a great question. I think it really depends on what we see as the harm. If the harm is the disclosure of the protected information writ large, then I think motivation's irrelevant. And I think that's part of the problem with the Espionage Act, the way it's currently crafted. That is the premise from which it proceeds, right? That once the information is out there in a way that could harm national security, it doesn't matter why it's out there. I think a more carefully tailored statute could very well take into account the kinds of things you suggest. If the goal was to reveal waste and fraud, or if the goal was to call the attention of Americans to an illegal government program, perhaps that would be a way to narrow the focus of the statute. The problem is the way the law is right now, there's no room for that. And so we can have that conversation here, we can have it on the editorial pages, but not in the courts.
Gentleman's time has expired. Gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman, and we appreciate the witnesses being here. We certainly do. But this Department of Justice policy, to get approval from the AG himself, I think merits coming back to. Professor, you had said the AG policy protects not only the reporter, but also the government. And I keep coming back to, so who's protecting the people? I mean, the people are the ones that are supposed to be protected. How about who's protecting the soldiers? Okay, we got a DOJ policy that protects the AG. We got one, it also protects the reporter. Who's protecting the Navy SEALs? Who's protecting the one that gave us the information that got bin Laden? I mean, who is protecting those who are helping us? And I'm not getting the impression that we have anybody doing that right now. I know that at this very table, we had the Attorney General of the United States testify before the full committee. In his words, there are political dimensions to justice. That goes against everything every law professor I've ever heard told me and taught me. It goes against everything every Democratic Party member teacher I had taught me. They knew this country. They knew what founded this country, and they, I think, instilled it in me. And somebody needs to be watching out for the people and for the man that's going to do 3 decades in prison unless we get firm about stepping up and helping him. Now, I would just like to know, if we don't have a special prosecutor, who is going to stand up and protect those who are out there protecting us? And as you're thinking about that, let me just tell you, a father of one of SEAL Team 6 members told me that after, and we don't have to wonder too far how SEAL Team 6 got disclosed, when we saw the vice president on TV saying something like, well, how about that SEAL Team 6? Aren't they great? Yeah, let's hear for them. And father, one of the SEAL Team members, told me that his daughter-in-law, their family, got pretty instant military protection because they knew that the vice president had just outed these guys. And then when the president picks that up and starts talking about SEAL Team 6, and then when you have the Taliban target a helicopter with nearly 24 of SEAL Team 6 members, who was out there protecting them when the vice president, the president, outed SEAL Team 6? We know the president can declassify, so there can be no prosecution there. But how about in these other cases? Is there anybody else that you could propose that would actually be looking not out for the government, not out for the reporter, but for the people, for those who are trying to protect us, other than a special prosecutor? I'd really like to hear who it is.
Well, Congressman, I think those are excellent points, and that explains why DOJ created this regulation in the first place. Let's go back to first principles. DOJ recognized that sometimes there can be an appearance of impropriety or a conflict of interest where the Attorney General and others in the presidential line of command are responsible for investigating
Well, let
wrongdoing
me
by
set
other
this
senior
straight, because you left this, that's why we have this regulation. Are you talking about the one that requires the Attorney General who believes there are political dimensions to justice? That's why we have to get his permission? Is that what you're saying? Is that the policy you're talking
Congressman,
about?
what I'm saying is that because of a potential for conflict of interest, there is a mechanism now for appointing special counsels outside the normal presidential chain of command to give them a measure of independence so that they don't have to get approval from superiors in the Justice Department or elsewhere before taking certain investigative steps, such as issuing a subpoena to a reporter. I think the example from 2003 is a very good example of how this regulation can work in practice. After it was alleged that senior administration officials...
All right, you're going beyond my question. My
Okay.
time's running out. Let me just also make this point, that this same Attorney General has appointed or asked for an investigation by an Inspector General at DOJ who got a tape of a conversation with a federal agent, and rather than acting like a true Inspector General or a potential prosecution down the road, she turns it over to the federal agent. You better listen to this before I ask you questions. We've got a real problem in the Department of Justice if that's the kind of special investigations we get. And my time's up. I yield back.
Okay, the chair will say that after he recognizes the gentleman from Georgia, Mr. Johnson, he will recognize himself for the last series of questions. The gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. And I'm just wondering, where was the moral indignity and outrage and the like that has been displayed before us this morning? Where was that when Valerie Plame, a CIA agent, a covert CIA agent, was outed by the previous administration? Where was the indignant outrage?
Will the gentleman yield? I was outraged Richard Armitage was not prosecuted. He should have been, and I still hope he will be, for outing her.
Reclaiming my time. I'm glad to know that there was at least one of my colleagues on the other side of the aisle that voiced indignation, but I think you may have been by yourself on that. And there was, seems like there was a protective covering that was hoisted upon the actors in that drama by my colleagues on the other side. But now, you know, we want to be more indignant than I think is required. Sometimes we have good leaks and sometimes bad leaks. Is that correct? I mean, Abu Ghraib was a good leak, and there are some leaks that are bad. Would you gentlemen generally agree? I see heads shaking, going up and down, so I think that means yes in America. Is that correct?
No.
Huh? That
No,
is
sir.
not correct? All right.
Sir, I'm a counterintelligence officer. Do not tell me there's such a thing as a good leak.
Well, I guess it depends on where you're setting, though.
I'm supposed to
America-
free, in a war, I'm supposed to free flow of information is the free flow of sewage, because they can cost lives.
Well,
They have done so, I
understand.
think, in the
Well, I mean,
60s.
you have some good leaks and bad leaks. I don't think you can disagree with that. We really needed to learn about Abu Ghraib, and so that we could correct what was going on over there. And you know, problem is that you know, sometimes our laws can go too far so as to chill free speech, and I think that's a conflict that we probably need to address here. Those memos, those torture memos written by Deputy Assistant Attorney General John Yoo and Assistant Attorney General Jay Bybee, advised the U.S. government that acts widely regarded as torture might be legally permissible under an expansive interpretation of presidential authority. at least one of these memos was leaked to the public, while others were obtained through litigation. The memos were widely criticized as legally flawed and morally indefensible. President Obama repudiated the opinions in early 2009. The source of the leak for those memos were never found, and we have leaks that have occurred throughout every administration that has served in America. Is there any particular reason why we should be so dramatically concerned about the recent spate of leaks that have occurred?
If I could, Congressman, you put your finger on an interesting point, whether there are good leaks or bad leaks. And some people will say, look, we have to allow some leaks because that's the only way information about wrongdoing within the government is going to get surfaced. But that's not the case. I mean, now Congress, in its wisdom, has passed a series of whistleblower protection laws, which say that if you're a whistleblower, in other words, you're a person within the government, you see something that looks like waste, fraud, abuse, or criminal conduct, you can take that information up, and in the intelligence community, you can take it up to the intelligence committees in Congress. The point being that there's an avenue for surfacing that information other than going to the press now. So the argument that you need to have press leaks in order to allow that is really not the case.
Do the whistleblower laws take precedence over the espionage statutes?
They do, and in fact, Professor Vladeck has spoken to this in today's testimony. There is some tension there, but the notion is that if you follow, as a government employee, follow the whistleblower protection procedure and disclose things to the right people within that statute, you will not be prosecuted. That's the idea. Now, there's a concern. Those things have to be sufficiently user-friendly.
Is that in the law?
The gentleman's time has expired. The chair recognizes himself for 5 minutes for the final questions. First of all, let me point out that in the case of the Valerie Plame leak, the leak was by an administration supporter, and there was a special counsel appointed, Patrick Fitzgerald, who is the U.S. Attorney for the Northern District of Illinois, and there were some very controversial prosecutions involved, which resulted in some convictions. I think we all know who was convicted. Now, the other thing is that I, agree with Colonel Allard, that there's no such thing as a good leak. A good leak is one that, you agree with who gets damaged in the national security realm, and a bad leak is that you disagree with it. Nobody should get damaged in the national security realm by a leak. And the thing is that if somebody is engaged in misconduct, the Whistleblower Protection Acts do provide for protection of a whistleblower who sends the information up the chain of command to people who have been cleared, including members of the Senate and House Permanent Select Committee on Intelligence. Now, having said all of that, this is a very difficult area to legislate in. And I don't think that we have the time left in this Congress to be able to deal with the various issues. First, I agree with Professor Vladeck that the Espionage Act of 1917 is outdated. The type of espionage that this country faces now is not the type of espionage that German spies did in the march to World War I. I would point out that there were a whole package of laws that Woodrow Wilson got passed, including a Sedition Act, which resulted in one of my predecessors as the representative of the 5th District of Wisconsin getting excluded from Congress twice, getting reelected by a constituency that Mr. Wilson decided, or the constituency that decided that Mr. Wilson chose the wrong side to fight for in the First World War, and he spent some time as a sitting member of Congress in jail for sedition. So, it seems to me that, the history of those kinds of acts mean that we have to update them. I am not for having an Official Secrets Act like occurs in the United Kingdom, but I am for revising standards for classification. And there ought to be some type of almost strict liability on someone who deliberately leaks something that he or she knows to be classified to somebody who does not have a security classification. And finally, and this is the question that I would like to ask, and we'll start with you, Mr. Weinstein, are there any circumstances where putting a reporter in jail for publishing a leak are permissible under the First Amendment?
I believe so.
And
And
what
I believe actually you can look at the iconic case, speaking of Midway, where the Chicago Tribune actually published the fact that we'd broken the Japanese code in 1942, which could have been devastating to our war effort and could have resulted in the loss of thousands, if not tens of thousands of more American lives. Under certain circumstances, you could see that if someone had done that with impunity and knowledge of the consequences and gone ahead and published it, that's something that I think would be worthy of prosecution and punishment.
You know, how about prosecution and punishment for those that disclosed it was SEAL Team 6 that actually went in and took out bin Laden? Is that the same thing?
It sort of depends on the facts and the consequences. I really couldn't sort of opine on it because in retrospect, I can see what it would have done to World War II. It's hard for me to know whether the fact that SEAL Team 6 it operates in secret, whether it's going to suffer the same damage or not, and also the intent behind the leak. That's a serious leak, though, something that should be seriously looked at by a prosecutor.
Well, you know, here we're talking 70 years after the fact of the leak on the Japanese codes on Midway. Perhaps 70 years from now, we'll be talking in this committee about the leaks on SEAL Team 6, which I think emphasizes the fact that we do need to update the laws. Professor Sales?
If I could, Mr. Chairman, just
Okay.
keep in mind the distinction between punishing and prosecuting the newspaper reporter. That's a very different issue from prosecuting and punishing the leaker. And to your question as to whether you should put the reporter in jail, that's a bigger step.
Okay, Professor Sales, and then my time's already up, but answer question.
Gladly. I think the answer to the question is yes, it depends. There are circumstances in which it certainly would be constitutionally permissible to hold reporters to the same criminal law standards that every other citizen in the United States is expected to follow. In fact, the Supreme Court in the Pentagon Papers case recognized that there may be circumstances in which it would be consistent with the First Amendment to apply the terms of the Espionage Act to reporters that publish classified information.
Thank you very much, and I'd like to thank all of the witnesses for appearing, at I think what is a very interesting hearing that has a lot of interrelated and difficult policy questions involved. I frankly think that in the next Congress, this committee should take a whack at trying to put something together that updates the law and attempts to balance competing interests and how they interrelate with each other. Recognizing the fact that at least at the beginning of this process, everybody will come in and testify against something that is in the law. But I think it is unacceptable to keep relying on a 1917 act to deal with the issue of leaks and as well as the issue of espionage, because espionage now is a lot different than it was in the First World War. That having been said, thank you all for coming, and without objection, the hearing is adjourned.
I've never been so glad.